there are several implications for a business that is subject to the Arthur WIshart Act. Of course, the disclosure requirements are those that come to mind quite often and are those on which we receive the most questions, particularly for people who think about becoming franchisors in Ontario or bringing their franchise business in Ontario. But we need also to look at other duties that are under the Act. One is a duty of fair dealing. The duty of fair dealing basically includes a duty to act in good faith and use reasonable commercial standards in the enforcement and the day-to-day operations of the franchise agreement. Also, it provides the franchisees with a right to associates. There is no possibility for a franchisee to waive its rights under the Act. So any wording that would be written in a franchise agreement or other document that would purport for a franchisee to waive its rights under the WIshart Act would be illegal. Also, the requirements of the WIshart Act are that a franchisee cannot contract out its rights to sue in the province of Ontario or have an arbitration taking place in the province of Ontario if there is a claim under the WIshart Act. And lastly, but the one where probably most of the time is spent by lawyers and will be spent for most of the rest of this webinar, deals with the disclosure requirements.
And going back for a second to the right to associate, the implications for a business subject to the Act. I've, represented franchisee associations, and I know that, it's important for franchisors to be very, very cautious of this right of franchisees to associate. A particular case I was just involved in, the franchisor definitely was not happy about the franchisees sharing information with respect to their franchise arrangements, and the franchisor treated them differently as a result and got into some hot water as a result of that. And you have to really be cautious of treating franchisee associations respectfully and dealing with them as a unit. As a franchisor, you could even turn that into a benefit in that some of your communication with the franchisees can be made a whole lot easier if you're dealing with a franchisee association rather than each one of them individually.
And actually, Ontario was the first jurisdiction in Canada to recognize the right of franchisees to associates.
Yeah. Okay, so now for the most important part, this idea of a disclosure document and the obligation to provide a disclosure document. So, when does this obligation arise? It's a pretty easy answer. In all cases, unless there's a specific exemption from the disclosure requirement. And we're going to go over some of those exemptions momentarily, but the onus is always to prove the entitlement to the exemption, the onus to prove the entitlement to the exemption is on the franchisor claiming the exemption. So you have to realize that one of our practical tips you'll see at the end, and our last point on this slide is when in doubt, disclose. And the reason we say that is because sometimes the facts are not clear that an exemption is available. So if you're going to rely on an exemption as a franchisor, then you have to know that if it ever gets challenged, the onus will be on you to prove that you have the entitlement to rely on that exemption. So that's something that you should be wary of. The right of rescission is for 2 years if no disclosure is provided. So that's a pretty severe remedy that's right there in the Act. And that just means that if you don't provide a disclosure document for a period of 2 years, a franchisee can come back and go after as a loss the investment that they've made and any losses that they've incurred with respect to that franchise. So there's a ton of case law on this point, and here in Ontario it's very franchisee biased. So as a franchisor, you got to be really sensitive to the obligation to provide this disclosure document. Again, my last point, and I can't stress it enough, is that when in doubt, disclose.
And to the risk of repeating myself, and when in doubt, we should always disclose, and not only disclose, but disclose thoroughly. The right of rescission for 2 years if no disclosure is provided has been expanded in many cases by the courts in Ontario to the point where some documents, some disclosure documents have been considered as being so deficient as to amount to no disclosure document, and therefore, although a disclosure document or something that was considered by the franchisor as being a disclosure document was provided to the potential franchisee, it turned out that the courts decided that this was not a document pursuant to the WIshart Act and allowed the franchisee to rescind within 2 years. And the requirement is so technical that even the failure of signing the certificate at the end has been seen as being a tantamount to no disclosure at all, and has allowed a franchisee to terminate the agreement or to rescind the agreement within the period of 2 years. Now, going to the exemptions from disclosure requirement. Those exemptions are set out in the Act, but as I mentioned earlier concerning the exemptions from the Act itself, and going back to our previous point that when in doubt you should disclose, I would say that less and less lawyers in Ontario advise their client to put all their faith in relying on those exemptions when they sell franchises, unless we are in certain cases where it is clear that the exemption is absolutely available and cannot be challenged. So the first exemption that is in the WIshart Act is if there's a resale of an existing franchise. However, as soon as the franchisor is involved in the resale of the franchise, either in the resale process or some new documents are signed in favor of the franchisor, even a personal guarantee, this exemption disappears, and then the disclosure requirement would apply. Likewise, the additional franchise to an existing franchisee would not be covered by the disclosure requirement, provided that there is no material change in the system since the franchisee first purchased the franchise. As we will see later on in the definition of material change, it is unlikely that no material change has ever happened in the franchise agreement or in the franchise system, over time. Sale by an estate or by the trustee of an estate of a deceased franchisee is also exempt from disclosure. Also, if a franchisee operates a store within a store, in other words, if within a business that is existing, if a person has a franchise, which would quite often be actually a distribution arrangement which otherwise would fall under the definition of a franchise, and provided that the sales generated by that arrangement would not account for more than 20% of the total sales of the business, of the overall business in question, this type of arrangement would be exempt from the disclosure requirement. Now this being said, however, we always have to remember that these are exemptions from the disclosure requirements, not from the Act, and that the duty of fair dealing, among other things, would still apply. Renewal of an existing agreement, provided that no material change has taken place, would also be exempt from the disclosure requirement. If the total investment to acquire and operate the franchise is less than $5,000, if the franchise agreement is for 1 year or less and there is no non-refundable franchise fee, if the franchise agreement or the franchise arrangement is also governed by Section 55 of the Competition Act, that would be the multi-level marketing arrangements, or if there is an investment of $5 million over a year, $5 million or more over a year, which would then be considered as being a sophisticated investor.
Thanks, Jean. So just getting into the contents of a disclosure document, franchisors are going to want to know what goes into this, prospectus-like disclosure document. And, the first point is that all material facts, including those prescribed by regulation. We'll get into those that are prescribed by regulation in a few moments, but I want to concentrate on the definition of material facts, because it actually is a defined term in the Act. And I'll just recite the definition for you. So the disclosure document has to contain any material fact. Material fact is defined as that includes any information about the business, operations, capital, or control of the franchisor or franchisor's associate, or about the franchise system. Franchise system is also defined, by the way, that would reasonably be expected to have a significant effect on the value or price of the franchise to be granted or the decision to acquire the franchise. That's what constitutes a material fact. All material facts have to be disclosed. And, as you can tell by the definition, it's extremely open-ended and broad. And that poses a concern for franchisors because, what is material? And, it leaves franchise lawyers with the conundrum of dealing with, their clients and making sure that they're disclosing everything under the sun that they think would be relevant to, a potential franchisee's decision to acquire a franchise. I'd also mention that, the definition of material fact includes information about the franchise system. Well, the definition of franchise system includes marketing and business plans. So, query whether you have to also disclose a marketing and business plan, to comply with the disclosure requirement, and that should be included. So, it's extremely broad. Franchisors have to be very sensitive to this in particular, and so moving on, financial statements also have to be included in the disclosure document, and they have to be audited or review engagement financials. They cannot be notice to reader financials. All the documents that are to be executed on the closing of the franchise, so that might include a general security agreement, a guarantee, a sublease, a consent and waiver, all these documents in the franchise agreement itself have to be included as part of the disclosure document and just appended as schedules. Getting into the prescribed statements. So the regulations to the Arthur WIshart Act contain certain statements that have to be included in every disclosure document. And, on the first page, typically you have a recommendation that independent legal advice is obtained for the franchisee. You also have another statement with respect to getting advice from an accountant and some financial feedback. So, it also goes into, a franchisor has to also disclose whether any of its directors or officers were ever convicted of a crime or ever, declared bankruptcy. So, the prescribed statements are also very important. And the last point is also somewhat problematic, but, the contents of a disclosure document must also be accurate, clear, and concise. And this poses another issue for lawyers and for franchisors of those lawyers, lawyers for the franchisors, because of the fact that it has to be concise, and a franchise agreement can be a very lengthy document. It may be difficult to scale back on the legalese to make it concise, but at the same time ensure that it remains accurate. So anyway, that's something that your franchise lawyer can help you out with for sure. But anyway, just be sensitive to the fact that the franchise disclosure document has to be accurate, clear, and concise.
And to just get back to the point that Andy was making, the concision of disclosure documents when you try to comply with a definition of material facts, which actually is open-ended and says that that definition includes the elements that Andy has just described earlier, but which means that anything else that is not necessarily part of the description but would have a significant effect on the value of price or the franchise or the decision to acquire a franchise needs to go into the franchise disclosure document. Basically runs almost counter to the requirement that the disclosure document be concise. And so it's a challenge to at least present it in a clear and accurate manner and make it in a as complete as possible manner. The other considerations regarding disclosure documents, if we go briefly over them, one is, and being the most important, I think, is that once the disclosure document has been given, there is a 14 days sort of standstill period, if I can call it that way, where the franchisor cannot sign any document related to the franchisor except any document that would have been signed by the franchisee related to the franchise, or also receive any money related to the franchise from the franchisee. Now, that poses a certain number of interesting situations in Ontario because legislations in other provinces allow, for instance, franchisors to receive refundable deposits or also allow franchisors to sign confidentiality agreements with potential franchisees before providing disclosure documents, or at least before the 14 days standstill period has ended. In Ontario, there is no such exemption that is provided in the legislation. Nobody yet has tried to be the test case in the courts, even after 10 years on that respect. And so the position that most lawyers will use in Ontario is that it is imprudent, to say the least, if not illegal, to accept deposits or enter into a confidentiality agreement with a potential franchisee prior to the expiry of the 14 days period after the franchise disclosure document has been given to the franchisee or the potential franchisee. The franchise disclosure document can be an Ontario document, or as some lawyers are doing more and more, what I would term as a Canada-wide document. As I have indicated earlier, there are currently 4 provinces in the country that have disclosure requirements. Manitoba will become the 5th one at the end of this year, on October the 1st. And therefore, there's something to be said about trying to have a disclosure document that would cover all the multiple requirements of each province. On the other hand, this becomes at one point a fairly convoluted document because the requirements for disclosure are not necessarily the same in each province, and even trying to achieve the highest standard of all would still require, in particular, some specific disclosures that are specific to each of the provinces, and which then make the disclosure document longer and longer, and maybe again the concision, the requirement that the document be clear, accurate, and concise might be lost in the shuffle. Wraparound documents are not advisable in Ontario, although they could probably be possible for documents from other provinces where you would add a section related to the Ontario requirements. But for those who are with us today and would be franchisors from the United States, it is definitely not recommended to use a American FDD and try to do an Ontario wraparound over that American FDD because there's too many differences in terms of the things that need to be disclosed, and particularly about the presentation of those disclosures, that it would again more than likely run contrary to the accurate, clear, and concise requirement of the WIshart Act. It also needs in Ontario to be one document at one time. In other words, you cannot disclose in dribs and drabs. Location-specific disclosure is also important to consider, particularly if we are in a situation where there is a renewal or a resale of an existing franchise, or if a franchisor sells a corporate store. There is at that point a certain amount of information that the franchisor would have concerning the location itself. That can be, for instance, sales figures that the franchisor would have for that location. And if we're talking about the sale of a corporate store or the sale of an existing franchise, that the franchisor should probably disclose to the potential franchisee. Also, one element that is seen quite often in renewal situations where the franchisor is also on the head lease is this. If there's a new head lease that is being negotiated at the same time as the renewal of the franchise agreement and of the sublease that will be signed under the franchise agreement, then the new head lease also needs to be disclosed. And actually, some of the recent case law precisely deals with situations where franchisors have failed to disclose, or in some cases have been less than forthright in their communications to their franchisees about what was happening with the negotiations for the new head lease. And this has cost dearly to the franchisors. Last point in those other considerations regarding disclosure documents is if there's a material change that is taking place between the time where the franchise disclosure document has been provided to the franchisee and the execution of the franchise agreement. And material change, at least this time, is not as open a definition as a material fact, but says that if there's a change in the business, operation, capital, or control of the franchisor or franchisor associate, that would reasonably be expected to have a significant adverse effect on the value or the price of the franchise or the decision to acquire the franchise, then that becomes a material change. And this material change needs to be disclosed. That can be simply as part of a one-page or two pages letter that is sent to the potential franchisee, which would then be considered as being part of the disclosure document. The question that we are often asked concerning those statement of material changes, how long do I have to wait after I've given a statement of material change? And although the Act is silent on that, the better position in Andy's view and my view is that we should restart another 14 days period and make absolutely sure that we are in the clear in order to avoid any inference that the franchisee might not have been disclosed properly, and then open rescission recourses.
Okay. So we want to finish by, going over our top 5 practical tips for franchisors. And I've harped on it in this seminar here, and I'll say it again, but when in doubt, provide a disclosure document. If you're relying on an exemption, I would look long and hard at the facts surrounding that exemption, and get some legal advice regarding it. But when in doubt, provide a disclosure document.
Yeah, particularly if you don't want to end up being the test case for some of those disclosures, it is quite often preferable to go to the trouble up front of preparing the disclosure document than having to go through the tribulations of litigation. If your sales teams believe that certain facts should be withheld from the disclosure document because they will not look good and they might not help the sale of the franchises, our own experience when we deal with franchisors and that question comes up and we look at the facts that the sales teams suggest that it would not look good if a franchisee or potential franchisee would be made aware of it in the disclosure document, we almost always come to the conclusion that they are going to be material facts as per the definition of the WIshart Act, and as a result, this should be included in the disclosure document. This is not a marketing brochure. This is a legal document, and going wrong on that document can have a lot of negative implications.
Third point is not to forget to include the location-specific disclosure where a franchisee is selling his franchise on a renewal of the franchise or on a sale of a corporate-owned store to a new franchisee. And this just gets into what is material. Back to the question of material facts that have to be disclosed. As Jean mentioned in the previous slide, if there is information relating to a certain location, that the franchisor has access to, that information will likely be material and should be disclosed, and you can include your own section at the very end of your disclosure document entitled location-specific disclosure.
Then to come back to a point I've made earlier, but this is certainly part of our top 5 for Andy and me, always wait at least 14 days after providing the disclosure document or the statement of material change before signing any agreement or receiving any consideration. And that goes as far as asking us if we can take a deposit in our trust account instead of having the deposit paid directly to the franchisor. And even that would run contrary to the WIshart Act and open the longer rescission period. Again, here it is a tension between the sales and marketing department for many franchisors and the realities of the legal requirements. And lawyers are often called, and when I was working in an in-house legal department, the legal department was referred to as the business prevention department, We're not trying to do that when we advise franchisors, and it is more a matter of risk management here. But we have to bear in mind that there's probably very few situations where the need to sign the documents within 14 days or in less than 14 days would be so imperative that it would be more compelling than the risk associated with not complying with that waiting period of 14 days, even after only having provided a statement of material change.
Our last point is just to be sensitive to the duty of fair dealing in the performance and enforcement of the franchise agreement. And as franchisors, you do have to remember that, first of all, with respect to bargaining position, typically franchisors are in a better bargaining position than a franchisee, and judges have looked at that. And you have to be very, very sensitive to the fact that, in the act itself, there's a duty of fair dealing, a duty to act in good faith. If you're enforcing certain provisions of the agreement, you should do so in good faith and deal fairly with your franchisees and use, commercial reasonableness in doing so.
And it goes in the performance of the agreement, and it goes as far also as renewals, for instance, and how renewals are being handled. And what we see quite often coming out of the courts recently are situations where the duty of fair dealing has not been respected by the franchisors in the way they have handled renewals, either by not being forthright about some of the elements of what was happening with the renewal and withheld some information, or also sometimes by trying to impose too many changes in the new franchise agreement that is to be executed on renewal, and that was changing the deal so dramatically that this was no longer a renewal. And so even there's a need to make sure that renewals are handled in a fair manner, in good faith, and using reasonable commercial standards.
If anybody has any questions, feel free to type them in. I think we've had 2 or 3 over the course of the last 45 minutes, so feel free to chime in. And to the extent that we don't get to your question, if you want to include your email address, we're happy to send you an email or hop on a conference call at a later point today, tomorrow, or next week.
We do have one question that's come in. First question being, can you send a PowerPoint or of the presentation? And the answer is, of course, yes. We'll send out a copy of the slides, and the recording of the webinar will also be posted online in a few days. Another question's come in. If you decide to franchise, how long does it typically take?
That question, there's 2 elements to that question. If you decide to franchise and you are not currently a franchisor, the business process will probably take longer than the legal process. You have to remember that franchising is, first of all, replicating an existing concept and systemizing that concept to a point where it can be sold to other people who can use the same elements that you have used successfully in starting your own business, and which they can use in a franchise environment. And so that means making sure that you have standardized your procedures, that they are documented in the manual, that you have also eventually made sure that that concept can be used in other markets than yours. This is why it is always quite advisable for someone who would have one store, for instance, or one business in one location, to open another corporate store in another market to see if that pilot project can work in a different environment than the home base. And once all that homework has been done and you have standardized your system and it is all documented into what will eventually become the manual, then it is time to involve the lawyers who will start preparing the franchise agreements, the disclosure document, and the related documentation. And also, quite importantly, make sure that you have a trademark that can be registered and that is available, and make sure that the registration process of the trademark is definitely underway. and you have not received any advice that you would have problems registering that trademark before you start franchising. The legal process itself of preparing the disclosure document and the franchise agreement would generally run for 3 months, more or less, based on at least our collective experience for Andy and me. By the time we prepare drafts, send it over to the client, point out a few issues to the client, particularly with the disclosure document, make sure that we flush out all the material facts. You can probably count on 3 months, but this is, of course, provided that the business side of the homework and also the financial statements and everything are in good shape by the time we start getting involved.
And one more question has come in, John, relating to the trademarks, asking what areas is it best to register for trademarks in?
Well, if you're talking about a franchise in Ontario, for instance, then you definitely need to have a franchise registered in Canada. We have to remember that trademarks are country-specific, and that if you have a trademark in the United States that is not registered in Canada, or that has not been in use in Canada, then your American trademark registration would not be valid in Canada, and you could not rely on it. And so definitely the trademark needs to be registered in Canada. And if your trademark was not registered in Canada, or if there were problems with your trademark or challenges to your trademark in Canada, that would then become a situation that would be considered as being a material fact and would need to be disclosed in the disclosure document.
Yeah. Okay, that's great. Thanks for attending this seminar. And again, on behalf of myself and Jean Bedard, we hope that you learned a few things, and feel free to get in contact with us if you have any questions in the future. Thanks a lot.
Thank you, and we look forward to hearing from you.